All right, let's go ahead and get started. As most of you know, Ellen Bacon-Wiley will be doing our presentation today. She's with California Appellate Project, formerly supervisor at Labor 2, and really needs no further introduction. So take it away, Ellen. Oh, and be sure when you have questions to use the mic.
All right, so I drank a lot of coffee this morning, a lot of material to cover. When I actually asked to do this training, and the reason I did is because we read every single one of those 2-6 records when you guys or your client files a notice of appeal from the 2-6. And I started becoming concerned with my colleagues that we sort of, and I'm speaking from experience here at Ladle, we sort of go through here's the notice, here's the exception. It's almost a very cursory thing. And I don't know that, at least when I was here, I did a great job of giving attorneys the whole picture and all the available arguments to them at the 2-6. We have a list of about 85 panel attorneys at Appellate. They are calling me complaining that every 2-6 ends up in a no-merit Phoenix H brief. They are legal nerds. They like to write. They like to make good law for parents when they can. And so we thought, well, let's go to Ladle, let's talk about it. So Gibran, who's in Lancaster, named this the appellate perspective. That felt like that was a lot of responsibility on my shoulders, so I changed it to an appellate perspective because I do not want responsibility for bringing to you the thought of everyone involved in this process. We get a lot, because I'm sure all of you in this room have made it, of general objections. We're not reading into anything beyond, well, they don't have a defense. I mean, that's really what it is, that it's probably going to be a Phoenix H. Because if you don't have anything but a general objection at that point, trust me, the appellate attorney is not going to find anything either. Am I dissuading you from filing a notice of appeal? Yes. If your client hasn't asked you to do so, you haven't had contact with your client since dispo, but you think maybe they don't want their rights terminated. You're not doing them any favors, okay? Or us, because we have to find an attorney. So what I'm going to try and get through somewhat quickly are notice. I'm not going to spend a lot of time on notice, guys. And the reason is because that's a whole nother training, and it's something that's pretty statutorily based and pretty easy to come up to speed if you don't know it. Adoptability, exceptions, I misled you here. I am not going to have time to go through all of them, so I'm going to go through the main two, which are the bond and sibling. And then collateral issues, which is all this other things that we see and that Javon asked me to try and include. So we'll start with notice. I put in the general provisions of the statutes. Publication has to be made once a week for 4 consecutive weeks. You need to note on your court appearance sheet when the court makes that notice is proper finding. And I would suggest that you also note for yourself why. Was it by personal service? So that if you took a vacation, you were out sick, and the court forced your floater or whomever to go forward in your absence, it's an easy way for them to flick back and see why notice was proper. They will like you for it, and the court will like you for it. Has to be made personally, certified mail. And they can only serve you after a due diligence has been done. Notice to whom? Mom, of course. Presumed or alleged father. The interesting thing, well, interesting to me, maybe not you, is a biological father is not actually required by the statute. But in practice, he is included. Child over the age of 10. Sibling of a child who is also under dependency jurisdiction unless they're on calendar for the same day. Grandparents, if parents' whereabouts are unknown, counsel of record, and the CASA or the de facto parent, which is not in the statute, but is in the rule book. Okay, so you get to court and you think that there is an error in notice. This is the standard that we have to abide by on the appellate record. When there's no attempt to serve a parent with notice, the error is reversible per se. Those are your Ainsley motions, where department knew about dad or mom, and did nothing, and then dad pops in at the 2-6 because he's been noticed, and he's like, wait, what's going on? And now you have to go through everything. Those are reversible per se, because it's a lack of jurisdiction. When we get to the 2-6, if there is an error, it's whether or not it's harmless beyond a reasonable doubt, which if you've worked in the appellate or read appellate decisions, you understand from a dependency point, it's a very difficult burden for the appellate attorney to prove. For the Ainsley motions, we get that, dad would have been able to participate in reunification, he may have had placement, he may have had relatives. When we get to the 2-6, if notice wasn't proper and you have a mom or dad who hasn't really been around, it's going to be really difficult for us to show that it was harmless beyond a reasonable doubt. So what do? We get a lot of, Your Honor, my client's not present, I'd ask to put the 2-6 over to figure out why they're not here. Denied, okay? Or I'm arguing notice isn't proper. Counsel, your objection is overruled. I found notice proper on this day, whatever. So what do when you really do believe notice isn't proper? How do you make that record to try and show, well, no, wait, this is not harmless. This is a big deal. And what you're looking at is, don't make your objections a calendar call on notice. Put them on the record. I can't read that you made an objection to notice. Your appellate attorney cannot read it. And most importantly, the 3 justices at the Court of Appeal cannot see that you put your objection on the record. So it's fine to say a calendar call, Your Honor, I'm going to be making a record, I don't think notice was proper, but you better circle back around and make sure you get that on the record. You want to say, why isn't notice proper? Your Honor, under the statute, it requires personal service. There was no personal service. What is the defect? So many days, not done, whatever. And most importantly, for our purposes, if you can, how would the outcome be different if the parent was noticed? We are looking here at the availability for a parent to testify about the applicability of an exception. Assistance with cross-examination of the preparer of the 2-6 report, to refute statements of the social worker or the foster parents in the report. You have to say on the record, Your Honor, I think notice isn't proper, my client's not here, here's where I need my client, and these objections and this record would be the same thing you would want to make if you have an incarcerated parent who is not present. Because for those cases as well, we have to get into this harmless error analysis. Sorry, I'm getting a little cold. And I'm feeling it. So the same thing with parents who aren't transported in custody. You want to try and make that record. You want to try and be specific. Okay, moving on to adoptability. Adoptability for every 2-6 at which termination of parental rights is at issue, this is your starting point after notice. The court has to make this determination, and it's a determination made by clear and convincing evidence that the child will be adopted if parental rights are terminated. Why? Because we don't like to have legal orphans in the system. Well, we don't like to. Maybe some people do. But the court wants some assurances that an adoption will happen within a reasonable amount of time. It's sort of morphed, this adoptability finding has morphed into 2 separate findings that may apply to your case through case law. The first one is generally adoptable. These are the kids that you are thinking of when you think of generally adoptable kids. They're cute, they're young, they're healthy, they're not going to school and smearing feces on the wall, they're not being kicked out of 8 preschools because of their behavior. These are the kids that the department wants to put on posters and websites to encourage families to do foster care and adopt. Specifically adoptable are the kids that fall in a different category. These are kids with real significant behavioral needs, medical needs, mental health needs, that they would not be adopted but for this foster parent willing to adopt them. So there's a difference between generally adoptable and specifically adoptable. Some of the bench officers, and I can't think of who it is off the top of my head, say, I think it might be Ibsen and Lancaster. I find this child generally and specifically adoptable. He's just covering spaces in the event of an appeal. As I said, this distinction has come out through case law. Sarah M. was the first one that basically said, look, if a child is specifically adoptable, then that gives us reason to believe that if this family wants to adopt that child, there's other families out there who want to adopt this child as well. So that's where that specific adoptability came from. If you really have an issue of adoptability, what the department's going to rely on, similar to the decision in Sarah M., is Jerome D., that there's other families and approved families who would be willing to take a child with these types of characteristics, and they also try and throw in the progress that this kid may have had in his or her behavioral challenges or mental health challenges since the removal from the parent. It is appropriate because we have a published case in Rate AA that says that they can do that. For the parents, what the important cases that you need to know are the ones that talk about where the child is specifically adoptable, meaning they're adoptable only because this family wants to adopt them. Then the evidence of the suitability of that prospective adoptive family is in play in the court's determination of whether or not the child's adoptable. So the first way you want to approach it is to parcel out whether the child is adoptable based in part or entirely on the willingness of the foster family to adopt, and watch for other considerations that sometimes I think we glom over, like the child's wishes. We recently had a case come in where the 8-year-old said, if I can't see my mom anymore, I'm going to kill myself. No one raised that. No one circled back to that statement. That's a problem, okay? That's a huge problem that could have made a really big difference for the parent on the appeal. Do not go into evidence of suitability of prospective adoptive parents unless you know you have something, okay? It shouldn't be a fishing expedition. So how do you get to adoptability? You have to look at that report. I know that they get thinner and thinner and thinner as the case goes on. If you're like me and you're in a hurry, you're looking to Visitation to see what your client's done in the last 6 months. But there's so much more to the report that is required and must be there. The details of what is required to be in the 2-6 report is dependent upon when your client's FR was terminated. It's set out in multiple statutes, but it says the same thing. So if your client only went to the 2-1F, it's in 2-1F. If your client went to the 2-2, it's in 2-2. If your client went to the 2-5, it's there. They have to list in it search efforts for an absent parent. I put this in bold, a review of the amount and nature of any contact between the child and his or her parents since the time of placement. How many times do you get the same paragraph about visitation through all the review hearings, and then you come to the 2-6 and you get that paragraph again with a line saying the foster parent says the mother is inconsistent in visitation, there's no concerns to report. That's not sufficient, okay? A review of the amount and nature of contact between the child and the extended family, evaluation of the child's medical, developmental, scholastic, mental, and emotional status, assessment of eligibility and commitment of the identified prospective adoptive guardian or parent, relationship of the child to any identified prospective adoptive parent, and a statement from the child regarding placement in the adoption. Guys, let's not be crazy, okay? You're not going to make an objection to the sufficiency of the report when the 3-year-old doesn't seem to understand the concept of adoption, okay? So use this one sparingly when it's really unclear whether or not a child who should be able to understand the concept of not being able to see mommy or daddy again is not interviewed about that. In an analysis in the likelihood the child would be adopted, I annotated it for you so that you could see, I think I'm going to go twice, yeah, so that you could see why this information is so important. Search efforts goes to your notice objection. A review goes to adoptability and exception. Adoptability, exception, adoptability, 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 exception, adoptability. This is your case. This is Well, you are going to make your argument to the court on why the court cannot find clear and convincing evidence of adoptability. Because the prospective adoptive parents aren't sure. Because they had a referral. I just read this case before coming. They had a referral while the 2-6 was pending for physical abuse and admitted to corporal punishment of the children. So these types of things you're going to have to consider. Here's how you remedy it. You make an objection to the sufficiency of the report. And I can count on one hand how many times I've seen this. Actually, I don't have to use my hands, because I never see it. And it needs to be made, because if it's not made, it's waived. So, I propose some little language for you. Please do not quote me at the California Appellate Project as having told you this, but you make an objection to the sufficiency of the report. It is not a request for contest. It is the social worker's obligation, Your Honor, under section 33622, whatever, to prepare a report consistent with the guidelines. This one is insufficient, and I am asking the court to continue, not set for contest, to continue the 2-6 and order the department to prepare an adequate report. It's huge, and I'm going to tell you why it's huge in a second. Because I had a 2-6 appeal. It's really hard to read, so I'll tell you the relevant part. This is actually a 2-page order for supplemental briefing on a 2-6 appeal. The court did not find the applicability of the beneficial relationship exception between mom and kid both appealed. We thought we were going along fine, yep, C1, B1, and then all of a sudden we get a 2-page notice and order from the Court of Appeal, which you don't want to see, and basically it says, number 6, whether mother objected to the adequacy of DCFS's section 2-6 report, and if not, whether the absence of an objection forfeits any challenge, and if mother forfeited, whether mother was thereby deprived of her right to effective assistance of counsel. We didn't bring it up, but they will. This is Division 1, by the way. Very parent friendly. But they will. Now, fortunately for all you sitting here in this room, this was a private attorney who represented mother at the 2-6 who did this, but this resulted in a very panicked phone call from the panel attorney who represents mom on appeal saying, they want me to say that mom's attorney committed ineffective assistance of counsel. What do I do? This particular one hinged on a question of whether or not the prospective adoptive parents were advised of their right to guardianship versus, it hinged on a lot of the information about what they wanted to do. But the feeling that we got was, Division 1 wants to reverse this, and they're looking for a reason to do it. Don't give them the reason to ask one of our attorneys to supplemental briefing on ineffective assistance of counsel. They did reverse it, by the way. They did not need to reach the issue of ineffective assistance of counsel to do so, thankfully. But it's an objection that is very seldomly used that needs to be used more. I'm going to run through this real quick. Henry BD was a very recently published case this year, and this is the horror story about what happens when you have an insufficient report in adoptability. The court terminates parental rights. The parents, mom and dad, appeal, saying that the bond exception should have occurred. While that appeal is pending, in comes a request for the court to consider evidence that's occurred since the notice of appeal and that TPR, which in the appellate world we were like, ooh, mind blown, because this never happened. And not only did the Court of Appeal let them bring in all this extra evidence, they also denied everyone's request just to stipulate to reverse the termination of parental rights, because what happened here was so egregious. In a nutshell, the agency, because this was not Los Angeles, this was at First Appellate District, Contra Costa County. What happened here was the agency was very aware of the problems with this placement and left it all out of their report. In fact, let me just briefly read to you. There was a subsequent A month after parental rights were terminated, the child was removed as a result of a petition based on physical abuse. The child had a busted lip. Then, when the court starts to inquire, the court says that was only a hint of things to come. In the course of a series of hearings on foster parents' objection, the court learned that more than a year earlier, the Bureau had conducted an investigation of sex abuse of minor in the foster parent's home, had failed to disclose it to anyone, that one of the foster fathers had had his parental rights terminated to his own biological children. None of this was disclosed, not one. So the court, the juvenile court up in Contra Costa County was like, oh my God, the horror. And was really, they quote what the judge was saying in multiple places because it's clear that she was appalled. To me, reading this, the fault falls with the agency and the Minors Council. I can't put any blame on Parents Council because they got the report. But when you see, like the record I was reading today, that there's been an investigation for physical abuse on the foster parents while the 2-6 is pending, you need to look at that, especially if you have an issue of specific adoptability, because it goes in there. Home studies. Javon asked me to put this in. Okay, quick note on home studies. There is no legal requirement that the home study be completed before parental rights can be terminated. However, in Salvador M, basically the social worker took the stand and was like, yeah, I think it's fine. I think grandma's going to be good, even though there had been a change from guardianship to adoption, and then a sibling came in. I mean, it was a mess. In that situation, the court said, no, there's no showing of adoptability. Okay, so how do you go to the 2-6 and make the record on return? You don't. You don't. And I did read it. That's why I put this slide in. Section 2-6 does not give the court discretion to consider whether or not the child can be returned home. Of course, the obvious exception is unless it's within the context of a 3-day petition requesting return. But you can't walk into a 2-6 hearing and say, Your Honor, let's kid back. Or, what we see more commonly, my client wants more time. It's neither one of them is appropriate legal objection or defense to a 2-6 hearing. Okay, so let's get to the exceptions. Oh, wait, what? We can't, because we have to do an offer of proof first. Yes?
Do I need that thing?
No.
Can you just, in light of what we just talked about, you're not obviously asking for the child to be returned home at the 2-6 unless you have a 3-day pending, but there is a lot of recent 2-6 case law where they really talk about the progress of the parent subsequent to reunification. Okay.
We're going to get to it. Okay, so offers of proof are not a unique thing, and they're not a new thing. In Appellate, we also handle Division 6, which is Ventura, what we call the Tri-Counties, Ventura, Santa Barbara, Santa Maria, San Luis. They actually have, counsel is required to file a written offer of proof that the court rules on before setting anything for a 2-6. So if you thought you guys were out alone on this issue, you're not. But what you can lay claim to is the fact that Tamika T, which is sort of the seminal case on this, did come out of Judge Zeidler's court in 404. I mean, generally, the brief holding of Tamika T is that it doesn't violate a parent's due process if the court requires an offer of proof before setting a hearing for contest on the issue of the applicability of an exception. In Tamika T, what Mother's counsel stated was, Mother will introduce relevant evidence to the exceptions. Okay, so the Court of Appeal had that to go with, and this heightened standard where we're going to try and uphold the trial court whenever we can, and as a result, we get Tamika T. What you can pull out of Tamika T is the language that they give you regarding what an offer of proof should be. And that is giving the trial court the opportunity to determine if there really is a contested issue of fact. It has to be specific. It has to set forth the actual evidence to be produced and not merely the facts or issues to be addressed and argued. So you're not going to say, Mother's going to testify to establish the C1B1 exception. You have to be more specific. And then they cite a civil case and says it adequately protects. We had a recent, it's an unpublished decision, so don't rely on it, that's why I didn't give you this citation. John Dodd recently got a reversal of Commissioner Davis in Lancaster, who I understand is doing this a lot, because she was not specific in that she was requesting an offer of proof at the 2-6. This was a combined 388-2-6 proceeding, and at the end of the 388, Mother's Counsel said, I'd also ask that regardless of whether the court grants the hearing on the 388 petition, that the court allow us to set a contested 2-6 hearing based off a lot of the same facts I just delineated, as well as the mother's relationship with the children, specifically child and child's age. And she tells me she has been visiting consistently and does engage in all parental duties when she is allowed to visit. Without specifically going back and addressing this issue of a sufficient or insufficient offer of proof, Commissioner Davis proceeds to terminate parental rights, and we have the appeal. And so what John was successful in arguing to the Court of Appeal was, counsel didn't even really need to make an offer of proof. The court didn't ask counsel to make an offer of proof, and any representations that counsel was making was within the confines of his or her argument on the 388, and lo and behold, the court got it. So the court did reverse it and say there was no clear request from the juvenile court that the court was requesting an offer of proof in order to continue the 2-6 for a contest, and therefore the court reversed the order terminating parental rights to allow counsel to make an offer of proof again or otherwise set it for contest. So for you guys, what you have to be clear on is the court asking you for an offer of proof? What counsel did here was sort of threw their offer of proof into the argument on 388. You don't have to go there yet. They're two separate proceedings. So you do the 388, and then if the court says, counsel, I'm going to need an offer of proof before I set it for the 2-6, then you're going to want to do that. And that's why we go to the next slide. Okay, number one is the juvenile court specifically requesting an offer of proof to allow you to set it for contest on one of the exceptions. And the evidence, you got to say more than I'm going to introduce evidence to establish the exception, Your Honor. I need to cross-examine the preparer of the report. That's always a good one. It's always in the back pocket. Evidence from visitation monitors. Grandma's been monitoring mom's visits through the entirety of this case. She has relevant and important information about the interactions between the parent and the child. Evidence from therapists. Evidence from instructors, which I'll circle back to in the confines of Amy's question. Or evidence to refute the information in the report. So many times I'm sort of like, just say the social worker doesn't got it right because they're getting the report from the foster parent. And so the information in the report is probably completely different from what your client is telling you. I, to be honest, am a little loath to say I'm going to call my client. I can tell you without your client taking the stand what they're going to say. Kid calls me mommy. Kid gets sad when I leave. We're very bonded. And I understand. I've been there. I know sometimes you have to call your client to let them go through those motions, to let them know that yes, you are fighting for your client, for your child, and you do have a chance, even when they don't. I get that. But think outside the box, because I'm telling you, if all you have is your client's testimony on their child calling them mommy, you're done. There's nothing we can do for you in the Court of Appeal or be able to make good law. But we're going to start with the exceptions to termination. The burden shifts to the parents, and the standard is preponderance, okay? There is a question now. Sorry, he's not sure.
Yeah, no, I have he's going. Well, you can hear me, right?
Yeah.
Okay. Is there any, are there any differences between live testimony and stipulated testimony for purposes of?
There's a lot. I will tell you from an appellate practitioner point of view, if you're stipulating to testimony, it means you don't got a lot. That you're trying to insulate your client from cross-examination where they may potentially be torn apart. That's how I read it. I do think that if your client is out there and available and ready, bring it at me, department, bring it at me, minors counsel, that I do think it reads better. I do know that there are some judges who want stipulated testimony to keep the calendar moving. If you are going to do it, it should be very detailed. And it really you should double check it and triple check it to make sure it's hitting all the main points that you would in live testimony if you were questioning the client. Okay, so we're going to start with, C1B1, okay? Preponderance again, and we're looking for maintained regular visitation and contact and child will benefit from continuing the relationship. Okay, so I threw some cases. I mean, consistent and regular visitation is not that hard. And as we'll talk about as we get a little deeper into the appellate cases, this is the reason why we have some issues with what the standard of review is for the Court of Appeal. Brianna S. is the big one. Mom, through the first 18 months of the proceedings, was sort of out and about and not doing much. And then, lo and behold, FR is terminated and mom's right there. Super consistent. And the Court of Appeal said not enough. So for me, what I would consider is prepare for your 2-6 at dispo. If you are waiting to prepare for your 2-6 until FR is terminated, you are not going to have an arguable issue at 2-6. Okay? There might be some cases that might be the exception, but you really have to prepare your client for termination of parental rights at dispo. Anthony B., father went through 5 months, no contact, and then came back in. These are all very common scenarios we see a lot in the records. Regular visitation totally is fatal to the benefit child exception if it doesn't occur, and the benefit of continued contact, you can leave those on your, okay. So making the record on visitation, for a lot of you this doesn't seem to be very hard. In fact, I've seen many cases where everyone stipulates to the court that, yeah, mom or dad has had consistent visitation. That's not the issue, the second part is. But if you need to make the record on visitation, again, get on this issue from the filing of the petition, then I changed it and said, okay, maybe I'll give you dispo, because maybe you'll get the petition dismissed. Move towards unmonitored, liberalized visitation as soon as possible at review hearings. The department in Los Angeles County moves very slowly. We have an unspoken hierarchy about first you get monitored, then you get unmonitored and monitored, then you get unmonitored, then you get day visits, then you get overnights. That's just the way the department works here. In Ventura County, the common order at detention is unmonitored visitation after 4 clean drug tests. That's the standard order. So those parents do move along much faster than some of the parents here. Ask for phone calls so that parents can keep in contact with the kids between visits. If you're just getting visits and you have kids who are verbally able to talk to mom or dad on the phone, or even like 3 and can listen and say, hi mommy, hi daddy, make sure that those phone calls are happening in between. Because it's got to be, I recognize that the standard order here is 3 by 3, but so that means that there's 4 days where they're not talking to them. So see if you can get the phone calls in addition to visits. Make sure that, this is very important, make sure the client knows how to contact you if visitation is not happening. At dispo, I used to always write down for the clients, if you're not in services in 2 weeks, and if you're not getting your visits within 1 week, you call me. And then if they called me, because they said, I don't know, they gave me a packet, everything's full, I did a referral to the social worker investigator in my office to sit down with mom or dad to try and help them. They need to know, because we see a lot of records where you guys try, and I appreciate your efforts, at the 2-6 to say, well, the social worker wouldn't return my client's calls, or you have the client testify, I tried, the social worker told me my rights were already terminated and I couldn't get visits. But that's not going to be enough. That's not going to be enough. So you have to be on this issue early. Consider utilizing monitors outside DCFS to monitor the visits, because you're getting the worker or you're getting a foster parent who obviously has a different interest in the outcome than your client. Make sure the visitation section of every report is not a regurgitation of the prior report. You can make sufficiency of the report objections at review hearings, guys, because it says what it's supposed to be in there. And if you look at your 2-1F and the visitation section is identical to what you saw at the 2-1E, that's a sufficiency of the report objection. Beyond the bench, we went to a seminar given by Judge Nash, who was formerly the presiding judge, now retired, who talked about reasonable efforts at review hearings and visitation. your visitation is appropriate. If it's not happening, that should be the subject of a reasonable efforts argument. And if that's not successful, then you should pursue, potentially, I'm looking at Steve Schoenfeld, a writ proceeding. Okay, so that's not hard. Well,
Quick
I say,
question.
yeah.
For parents in custody, are phone calls enough? Are there any cases that highlight the importance of telephonic contact? Because I've had cases where the court just won't even order it. Like the kid is 3, and they'll just say, "Oh, it's not going to be."
And that's why I say partially resented. That has to be talked about at that time. That needs to be an objection. That's an appealable order. If the court is ordering no visits until out of custody or no phone calls, then that means that's a separate appealable order that needs to be dealt with before. There are a lot of cases about what case plans for incarcerated parents should look like. And unless there is a no contact order or the court has found that it's detrimental to the child, then that incarcerated parent should be having visitation via phone, via Skype, via whatever might be available to them in their place of custody. Otherwise, it's a reasonable efforts issue. Yes?
When it comes to a child who's a little older, so like for instance, a case where the child is 10, sometimes there's issues with visits because of monitors, but I mean, it's clear a child at that age who's able to say, I have a relationship with my mom, I miss my mom. Like the older child would it be true that the less visitation is really important to make this case? Because 6 months of visitation with spotty doesn't undo the 10 years in which she was with mom's home.
I don't disagree with you, but I don't have a case like that from the Court of Appeal.
Okay.
Their approach to it is basically like it doesn't matter what you did, because if you didn't have, if all you had was 6 months of consistent and regular visitation, you don't have a defense. So I don't disagree with you, but I think in terms of the cases that we've seen come out of the court, they want it through the entirety of the case as much as possible. Okay? Yes, Emily.
So just a suggestion that I usually make when I'm training is after disposition, the client is leaving with monitored visits. I would always document in my file that I told the client to call me in 2 months if they were still at monitored visits so we could file a 388 before the next review hearing. Because that way you're then putting overnights and or return on the table for the 2-1E review hearing rather than just, oh, we'll give them unmonitored visits and give them 6 more months. And then, of course, this will continue to assist once we get to the 2-6 if we don't get return.
All right, so then, okay, so development of the beneficial relationship. I don't need to tell you all what Autumn H says because you all have heard Autumn H until you're green in the face. This was the first case that came out after the amendments to the 2-6 statutes were made, and that's why it's the most commonly cited one. It's the significant positive emotional attachment. The cases that followed Autumn H are essentially the same. The caretakers have provided for 25 months. The parents took the stand and they're like, yeah, we don't know anything about this kid's needs. Bailey J, mom's contact did not amount to little more than play dates with a loving adult. So these are the ones that you guys are hearing because the county is citing them significantly more of a peer than a parent. Those are the types of ones. So here we were, all going on, and I should have put the stop sign in this one too because then in 2016 we had Noah G. And Noah G on paper was the perfect C1B1 case. The mom was living in the same apartment building with maternal grandma who had custody of the kids. She was driving them to school. They get home from school. She'd make them meals. This was the perfect case until it was pointed out, and this is the basis of which the Court of Appeal upheld or reversed the lower court, was that mom never addressed her drug problem. The case came in because of drugs, and mom never did a program. She claimed she just quit, but that didn't satisfy the Court of Appeal. So all of a sudden, we had this, wait a minute, you can't have a beneficial relationship without progress on the case plan? And the answer, sadly, guys, is yes. Unfortunately, yes, that's where it's gone. So then following, we had Brianna S., where mom hadn't addressed DV, she was still with dad, and therefore no beneficial relationship. And GB was probably a precursor where the mom had just begun to talk about domestic violence and the reason the cases came in. this is why it was important for me to get back over here, because now we have NRA Cadence-C. Cadence-C was published last year. It is not a Los Angeles case, it is a San Francisco case. The minor appealed on this case. The court did find at the juvenile court level the substantial bond beneficial relationship exception and put the kid in a long-term foster care. The adoptability, not an issue. Mom's visitation, not an issue. The issue was the beneficial relationship part. The minor loved the mom, wanted to live with her, but then this is what the court says. The court says, Caden's connection to his mother has never been the cause for the removal. In other words, the existence of a strong mother-child bond is far from the end of our inquiry. Having found the existence of a beneficial relationship between mother and Caden, as well as regular visitation, the juvenile court was charged finally with determining whether that relationship provided, quote, a compelling reason for concluding that termination of parental rights should not be pursued. I'm sorry, did they just drop another prong to the C1B1 exception? They did. Compelling reason went into the statute largely unnoticed back in 1998. And until Cadence-C, there was sort of this argument in the Court of Appeal about whether or not the existence of a bond was the compelling reason. And Cadence-C basically says, nope, that's not enough. I can count again on 2 hands, although I don't need them, how many times I've seen compelling reason on the record, which is none, which I'm not faulting you guys for, because until Cadence-C, like I said, this had not been on our radar. Our position, at least in the way that we drafted the briefs to the Court of Appeal, has always been that the strength of that bond, that it would be so detrimental to break, provides the compelling reason that the court needs to not terminate parental rights. But now we have a published case that disagrees with that assessment. The other sort of side issue to this was there was some disagreement about whether or not mom had maintained her sobriety, whether or not she actually had completed the case plan. Cadence-C, right now, why I bring it up to you, is on review in the California Supreme Court. The important thing to know is it has not been depublished, so as of today, it remains good law. The Supreme Court granted on 2 issues. One, the standard of review, which, like I said, it has been an ongoing split in the Court of Appeal for a while. What standard of review do we apply when we're reviewing at the appellate level, whether or not the exception applies? And 2, here's the one that's probably most important for you guys, whether a showing that a parent has made progress in addressing the issues that led to dependency is necessary to meet the beneficial parental relationship exception. So here we go, okay? This is where we're headed with the California Supreme Court weighing in on whether or not a parent's participation or compliance with their case plan is part of the beneficial relationship exception. I'm going to be honest with you, it's not looking good for parents, because this case right now is in the amicus brief filing, CLC file 3, one on behalf of Sacramento, one on behalf of LA, one on behalf of San Diego, and Cadence-C, it was the kids' appeal. So they're asking the Supreme Court to affirm the judgment of San Francisco. I have seen one amicus filed on behalf of the parent. So it's not looking good, but it is in progress. It's still in the briefing stage. And so I would not expect argument until maybe this summer and a decision maybe at the end of this year. So making the record on bond. How long has the minor lived with the child? Or mother or father lived with the child. I put minor lived with the child. Any advocacy efforts on behalf of minor? Do mom or dad know? This is my kid's special need. This is my kid's medical need. This is the regional center services he or she is entitled to. Medical needs, the child's relationship with extended family. That should be in the report, but you could also elicit it in testimony. Consider having someone other than or in addition to parent testify, a visitation monitor, family who's been present. And then, I see this a lot. You guys appropriately get mom on the stand and say, and mom, why was the case brought in? And what was your case plan? And counties jump, oh, objection, not relevant. Absolutely relevant. That's what we have under cadency and NOAA G. I have to get that information on the record, Your Honor. That's part of the beneficial relationship exception that's under review by the California Supreme Court. So make sure that that is all on the record. And then, guys, you have to circle back and talk about compelling reason. Why is this case so unique? Why, out of the 10 2-6s that the court's hearing this week, is this the one that deserves to defeat termination of parental rights? You have to, the words compelling reason have to come out of your mouth, because now we have directive, at least for the time being, that the bond is not enough. The bond is not enough. So now we have to push it a little further and show, Your Honor, this kid has so many ties. The kid is not really in a permanent home. I mean, whatever you can pull out of the ether to try and meet that, now we have compelling reason. We don't have a lot of cases telling us what a compelling reason is either. Gibran asked me to put in bonding studies. I'm going to go through it pretty quickly, and I put the cases down for you if you want. The Court of Appeal seems to be sort of meh, but one thing's clear. They are not going to overturn a juvenile court's decision to not order a bonding study, especially if it's done on the eve of a 2-6. And that is Richard C. Their position is, look, we have to get this kid to permanence as soon as possible. If mom's counsel is going to request for a bonding study at the last minute, we don't have authority to try and, stop it, to order that. It's an abuse of discretion standard on appeal, which is very difficult to come into. The other quick note I have, and the cases are here, are post-adoption contracts. Hold on, Emily. Post-adoption contracts, the genesis of this is in the family code. It was designed for third-party adoptions, where mom and dad have relinquished to a certain caregiver, and they want to keep contact. There's no real corollary, and I feel like dependency has tried to fit it into a box. Kimberly S., which I may have forgotten to put up there, but I have the site if you want me to email it to you, basically says there's no mandate. There is no mandate for bonding studies, even though they did reference language in the family code in section 2.6. The juvenile court is not required to notify every parent. Gibran had asked me to talk about timing. There's nothing about timing in the case law that I could find or in the WIC. I do think it's just a matter of practice. Unless it's changed, when I was here, consortium who sat down with everyone and did post-adoptive contracts wants that case referred right after TFR. So there's nothing legally about it. The only cases that I could pull up on it were on the validity of them. Okay, what's my time?
We're at 105.
Okay.
106.
Okay. Okay.
Can I ask a super quick question?
Yes.
Wasn't there recently a case that dinged Parents Council for not requesting a bonding study?
There was. I think was it unpublished or was it published?
It definitely dinged Parents Council though, and that's why we all got a little hysterical.
Yeah.
Okay. It must have been unpublished. I'm not. It wasn't mine. I can tell you that. As a personal view, Emily, I think bonding studies can be very helpful. If you have a case where you feel really strongly about the potential, I do think it's inherent on the court to have an expert weigh in under Evidence Code 730, and that's the umbrella for the bonding study. The problem for the Court of Appeal has been when counsel waits too long, headed to the 2-6, and now you're on for a 2-6 and you want to send it for contest and you're saying, Your Honor, I want a bonding study. That's when the Court of Appeal is like, no, we're not giving it to you. So I am a big proponent of them. I think they're helpful, but the issue is for the Court of Appeal is timing. Okay, so we're going to go.
So, I'm sorry, Ellen,
Yeah.
so would you say do that like at the termination of reunification services?
That's just an appellate perspective, Christina. Okay, so then we're going to move to the sibling exception. There's a lot of confusion surrounding the sibling exception because it is a defense for parents. Why? Because if you show that the sibling exception applies, parental rights are not terminated. And so that gives your client an interest in that outcome, which means that you can raise it as a defense. And LYL was the first published case after the sibling defense went in, sort of ferreting all this out. There is no automatic right for siblings to participate in a hearing at which parental rights may be terminated. Those siblings have to first file a 3D8. I know this gets into all kinds of issues with when CLC is going to declare a conflict and all types of things. If you are really feeling like a sibling defense is appropriate, at least talk it through with the child's attorney to see. They may, after talking with you through, be like, yeah, I got a conflict. I got to get one attorney on this case, and I've got to get one attorney on this case. But the siblings cannot just run into the courtroom and be like, hey, I object. That's not how it works. It has to be a 388. And that includes non-dependent siblings, too. In order to have standing in the proceedings, they have to file a 388, and the court has to rule on it. Well, hi.
Does it include adult siblings?
Yes.
Okay, thank you.
Okay, the right to raise the sibling exception at the appellate court level is waived. You don't say it. Our trusty appellate attorneys cannot raise it for you. Celine R. was a Supreme Court case that resulted out of everybody being like, I don't know, it's going to be hard on the kid. And nobody really knowing how to apply the sibling exception. The important part about Celine R. is it sort of goes through who the parties are. So when you're looking at the effect of termination of parental rights and whether or not it will be detrimental to the child, you're looking at the child who is being put up for adoption. The fact that her 14-year-old brother, Johnny, it's going to be really hard on him, that's not the court's consideration. You have to prove that Celine, who is getting adopted, it's going to be detrimental to her. So that's why it's difficult sometimes for parents' counsel to raise it. And I'm certainly not telling you not to if you think it applies, but if minors' counsel is not on board. We do have a split on authority. There's a split on authority about whether the sibling relationship terminates at the termination of parental rights. So in the one column, we have other dependent kids who have been adopted out, and they tried to come back in on Eric's 2-6, and the Court of Appeals said, no, you're done. There's no longer a legal relationship. On the other extreme, we have Valerie, which basically says, yeah, we don't know. We think so. The distinction for the court is biological versus legal. When you're a parent, there is a biological relationship, but there's also a legal relationship. You have care, custody, you have state rights to that child. Sibling, I mean, what rights do you have except for my sister to raid my wardrobe every once in a while? I mean, there's no rights and responsibilities, and that's where that distinction comes out. So if you do have kids who, were maybe not in the dependency system, or who have previously been adopted who want to come back in, try it. Because we don't have a firm answer on whether or not they have standing to participate. Unlike this situation, I think I skipped this slide in the parent relationship. Parent beneficial relationship, though, post-adoption contacts are not relevant. Not relevant. And I put the cases in there for you where the Court of Appeal is pretty firm in saying we're not going to terminate parental rights based on an adoptive parent's representation that she's going to let mom see the kid after the adoption is final. So they are not relevant. In siblings, the courts have held they are very relevant. Again, because we have this issue between legal versus biological rights. So the court can consider the sibling relationship if the two prospective adoptive parents or the two relative caretakers are saying, oh yeah, we'll continue it. And there's been a pattern where throughout the entirety of the case, sibling visits have been facilitated by those two parties. The court can use that in a consideration of whether or not it would be detrimental to the child. For parents, no. I don't want to hear it in the report. I don't want to hear it come out of anybody's mouth because it's been very solidly established that the court cannot consider that, and I did put those cases in the slide. So if you have a sibling bond, raise the exception if appropriate. Talk to counsel of minors who are in a different permanent plan to ascertain their positions. Consider dependent minors' relationships with non-dependent siblings and half-siblings, going to Becky's question. Ensure that sibling contacts and relationships are adequately set forth in the reports in the case. Okay, so then I looked at what I was doing and I was like, oh my god, I have so many slides. So now we're just going to go to quick notes. 388 petitions. The general rule is that the court has to rule on any pending 388 petition before proceeding to the 2-6 hearing. And the published case which you may need to rely on is Elia J. And in that case, the court said, oh, well, I'll consider that 388. But after I decide whether or not I'm going to terminate parental rights, I'm going to do this first. And sure enough, the court did the 2-6 first, terminated parental rights, and then denied the 388 because the parent didn't have standing anymore.
Oh my god.
Can't do that. You can't. Probably can't. You can't do that. Okay, if there's a pending 388, the court has to make a ruling on it before proceeding to the 2-6. There was a flurry of emails between Emily, Marlene, and I last year on relative placement. Many of you come into the 2-6, you argue relative placement, you do what you can with the facts presented to you, and the court says, no, this kid's been with the foster parents for 18 months now, I'm not changing the placement, so you turn around on behalf of the parent and file notice of appeal. We have a hard time giving your client standing on the relative placement issue. And the reason is because the shift, of course, has moved to permanency. We're not talking, it doesn't really matter where the parent wants them to go because their time is done. They have to move to permanency. So watch those because you're going to probably get a Phoenix H. To make it sort of float, you're going to have to look at relative placement early and consistently. I read a record yesterday where paternal grandma was there, then gone. Nobody brought her up again until the 2-6. So you have to, at every hearing, you should be reminding yourself what's going on with relative placement. Get minors counsel on board where possible. Get it? And tie the placement in with the parent, okay? Grandma, you need to make a record that grandma wants placement, she wants legal guardianship, she wants something that's going to be less than termination of parental rights. Because if we don't have a record showing that the outcome would have been different if the kid had gone with grandma as opposed to the foster parent, we're done. We can't do anything under NRAKC in the Supreme Court precedent. Now, if I, as mom, can raise an argument on appeal as to the C1B1 exception applying and the court erroneously denying it, and I can bring in the relative placement. But if relative placement is your only potential issue on appeal, you've got to have made that record. Or you could get the disgruntled relative a notice of appeal form because they can appeal too. We do appeals for what we call third-party appellants, and I have one right now where the adoptive relative, the kid was yanked from her, she's filed a notice of appeal. It doesn't always follow that the Court of Appeal is going to give them appointed counsel, but in some divisions they do. So don't dissuade the relative who wanted placement from filing a notice of appeal. It's possible. Oh my god, I did it.
No questions?
No questions?
Okay.
Go ahead and take one. Oh, fill out one deep. This? Okay.
Nailed it. Thank you.
Man, shout down.
Not even a little bit.
Fantastic. Yeah, I sent you an email, but so the new file, so I got the backup of that file. I just caught Adobe Excel documents in that same file in the same place. We'll do had it under new, okay? The original one that's not working anymore, it's gonna stay there because I don't want to delete it and then wipe it out completely, okay? So just start using the one that says new. Okay. And you'll see it on the same place.
And leave the other file alone.
Okay, as always.
Thank you. Sorry, you waiting for anything?
Yeah.